SJC-13041, Robert LeSage v. Massachusetts Treatment Center.
Attorney Murray, good morning.
Good morning, Madam Chief Justice, and may it please the court. First of all, thank you for allowing me to appear in person. It's a pleasure to be back in court.
Well, welcome.
Thank you. This court said in its COVID orders that the pandemic constitutes a compelling reason to postpone trials, and that it's in the interest of justice to do so. The pandemic is the sole reason for the delay of the case at bar. It's the sole reason for the delay.
All right, so counsel, with that in mind, how
Yes.
does the LeSage case affect your claim?
The Commonwealth answers that by saying LeSage applies with even greater force here, because the individuals in LeSage were held pre-trial on a finding of clear and convincing evidence or probable cause to believe that they had committed a new crime. Here, the petitioner, as all sexually dangerous persons, are held on a finding beyond a reasonable doubt. And in Mr. LeSage's case, there have been 4 findings beyond a reasonable doubt.
Counsel, do you agree that the standard here is strict scrutiny?
No. The Commonwealth's viewpoint here is that the pandemic, the statute has been found to meet and pass constitutional muster. The statute has been found to be narrowly drawn for compelling reasons. And as
I guess I'm not asking whether or not you win or lose under strict scrutiny. I'm asking whether strict scrutiny applies here.
not to the question of whether a jury trial is appropriate.
Okay, and so what standard would you posit applies?
The standard that the Commonwealth says is whether there's been a substantive due process violation here has not yet happened. And that's because the statute is narrowly drawn and the Commonwealth.
It seems to me you're answering the question under strict scrutiny because you're asking me to apply whether it's narrowly drawn to a compelling government interest. Is that what you're saying?
It is narrowly drawn, yes. So even if we apply a strict scrutiny standard, the statute passes.
So the government doesn't have a position as to which standard should apply.
No.
Just it should be under strict scrutiny. Even if we apply that standard, you're saying it passes.
It does, because
So what is the compelling government interest here?
The compelling government interest is, as this court has said, protecting the vulnerable members of the public, and as the legislature has said, from risk of sexual harm from people who have been found beyond a reasonable doubt to have a condition.
How is the public at risk here if we go forward with a Zoom trial?
A Zoom trial.
Bench trial.
Okay, well, I'll take them in turn. The Commonwealth's position and the legislature's position is that is in preference of a jury trial when either party so requests it. And that's because the statute says when either party so requests it, it shall proceed as a jury trial.
But that's a statutory right, correct?
That is correct.
The government has. Don't you have a problem that the constitutionality of the statute, as we've said many times, depends upon the time and the right to review, a current right to review for sexual dangerousness? And here, the petitioner has a right to review every year, and he may have been denied 4 times, but now he's 80 years old and things change, and he has the ability to go forward under the statute. So how does the statutory right that the government has to insist upon a jury trial trump his constitutional rights to timely review?
Well, first, the statute does not provide for an annual trial. The statute specifically provides for the annual filing of a petition. The statute is silent as to whether, how long the time frame is for the schedule.
I'm quite aware, as you know, of what the statute says, but haven't had a few trials with you. But the issue is the statutory scheme requires a periodic review. That's the only way this is constitutional, because this is the classic year to a day, and he has a right to his timely review. So how does that trump, again, your right to insist upon a jury trial?
First of all, the delay at issue here, solely pandemic related, as we all can agree. No cause by the Commonwealth. The delay here is so far less than this court has for decades evaluated and found not to violate speedy trial rights.
And can I just ask you to specify the delay here? Are you talking about the delay from July 2020 when he filed his motion to go forward
Yes,
to
and
date?
even if we only looked at that period of time,
So that's 6 months about.
and that's far less than the delays that this court has considered in DeBella, in Knapp, in Trimmer, in a series of cases.
So before you jump over the 6-month issue, why don't we go back to July 2015 when he filed his petition? Why isn't that the metric from 2015 and to date? Why is it from July to date?
For several reasons. First of all, number one, he had a trial in August of 2018. And as this court said in GF, a different circumstance where there had been mistrials at a pretrial, at a initial commitment case, the mistrial restarts any speedy trial clock. Number two, Mr. LeSage did not at any time contest either the first trial date or the second trial date for the retrial. And so there was no objection to those timeframes. And when we look at the record, it's clear Mr. LeSage was not prepared to go forward at any point before those dates because Mr. LeSage sought funds for his experts for the first time in May of 2018, shortly before the August trial date. Those reports were due under the standard scheduling order 6 weeks in advance of trial. And then for the second date, Judge Cannoni issued a trial order in March of 2019 for March of 2020. There was no objection, and counsel for Mr. LeSage moved for funds in January of 2020, as you see on the docket sheet, which begins at page 6 in our first record appendix volume. So the petitioner was at no point ready to go forward to trial earlier than the two trial dates. This court continued all trials under its general superintendent's power until July. And there has not actually been a judge in the Section 9 session since the end of the June term, which was the first few days of July. And the first expected arrival of a judge, so far as we are aware, is April. There's no judge signed for the first quarter. The judges
Ms.
typically
Murray,
sit
though,
by camera.
over here, there is a point in time where we have a substantive due process issue. We're just trying to find out where that point in time is. In Justice Gaziano's GF case, we discussed that. And former Chief Justice Gantz, when he addressed LeSage, pointed out that, we have to see what's going to happen. I think he made a comment in that case, well, and things seem to be getting better and jury trials are scheduled to start again in September. That didn't come to fruition. So there is a point in time where this happens.
Correct. In this,
And my question is this: when we're trying to gauge when that point in time is, do we have to look at whether or not you can have a fair and impartial bench trial? Is that a factor in trying to determine what that date is where substantive due process occurs?
no, the Commonwealth's position at this point is that we have not yet reached the point, and we are guided, in fact, by this court's order from September, the fourth COVID order, which found that all of the time through phase 1 and phase 2 is excludable time for criminal cases. If it's excludable time in those cases, then it cannot reasonably be argued that it's not excludable time under any speedy trial
So
calculation
I
here.
completely appreciate that point. And, the preface to Justice Gaziano's question was, we're talking about constitutional issues. My question is really specific. It's when we are trying to gauge this line of substantive due process, do we have to take into account whether or not the Commonwealth can have a fair trial and an impartial trial with a bench trial, despite what the statute says? Does that factor into the substantive due process analysis?
No, this court has said that it will only override the legislative's directives when there's a compelling constitutional basis to do so. And we have not reached that point yet. The Commonwealth is prepared to proceed with a jury trial, We said that in our papers. We said it at the at the hearing before Judge Cannoni in September, and I'm saying it to this court today.
Right.
The
Counsel,
Commonwealth is-
can you tell me when we'll reach that line? If it's not today?
The Commonwealth's hope and expectation is we'll be, and invites the court to exercise its superintendent's powers to have these cases brought forward, included in a session, which will obviously determine
Right,
where.
but you say right now that there's no constitutional violation, not at this point. And I'm asking, when would, in your view, would there be one?
Not this year.
Ever? What?
Not this year, no.
Not
In the
this year,
Commonwealth's
next year?
Not this year, possibly next year, and we would have to revisit it. But
Okay.
in the Commonwealth's viewpoint, these cases could reasonably be started for trial in the spring, depending on the availability of a court.
Could you, this is a variant of Justice Lowy's question. Could you articulate for us the governmental interest in a jury trial as opposed to jury waive trial?
Yes, it is because the citizens of the Commonwealth bear the consequences when people are released from civil commitment, and they should have, through their jury service, the opportunity to be heard. The legislature amended the statute in 1994, the very day after this court said there was no constitutional right to a jury trial in an SDP discharge proceeding.
So it seems to me that in answer to my question originally, what is the compelling government interest? It's not the safety of the public so much as it is its exercising of the statutory prerogative to insist on a jury trial.
Well,
That's the compelling interest.
Justice Wendland, the one fosters the other. Having the voice of the community, which the courts have held for centuries, the jury as the voice of the community, the conscience of the community, fosters the protection of the public.
So if that is the compelling government interest, in answer to Justice Lowy's question, I was puzzled that you did not say that the ability to conduct a jury waive trial is something that would factor into the second part of the strict scrutiny test. That is whether or not that government compelling interest is narrowly tailored. You know, that this insistence on going forward on a live jury trial is the only thing that will serve that compelling government interest.
In the Commonwealth's viewpoint, it is.
And I guess I'm puzzled by that because just in December, the Commonwealth was arguing that going forward in a criminal trial was required via Zoom. And now you're saying it's not good enough because we have the statutory jury trial right.
Well, first, the argument in Vasquez-Diaz, which I had the privilege of watching and reading the briefs, was at a preliminary stage of a criminal proceeding. But I share the concerns of what virtual proceedings do. And we have opposed.
I know,
obviously,
because it was
virtual proceedings.
interesting reading your brief in this case was almost as if you had copied and pasted the defendant's problems with going forward on Zoom and a motion to suppress in Vasquez-Diaz.
Actually, I didn't, but
No, I'm not suggesting that you did. I'm saying that they read very similarly.
And because they raise similar concerns, evaluating credibility, who will be the decision maker? Now, in a motion to suppress, of course, the judge is the decision maker. That is a different issue than here. And in a criminal case, the Commonwealth does not have a right to compel a jury trial when there is a statute and a rule that permits waiver.
We have two separate issues. One is the jury waive trial, and the second is how it's going to be done. You could
Correct.
have a jury waive trial that's done in person as well, and especially in an SDP proceeding where it's experts.
And the credibility of the experts is key, and judging credibility is best done in person, but as this court has said in several cases, because of things the camera cannot capture. And for all of those things, the behavior.
I guess this gets us back. This is kind of the Zoom trial is a nice issue, but more importantly is the jury waive trial issue, because we could do those in person tomorrow.
The jury waive trial, in the Commonwealth's view, there is no compelling constitutional basis at this time to proceed. And speed is just one of the important issues with a trial.
Is there ever a case that formulates the Commonwealth's right to a jury trial the way you do? Normally the right to a jury trial is, the defendant has a right to be tried by a fair cross section of the community. You're arguing that the Commonwealth has this public safety interest. Has any court ever done this? Ever articulated this way, your interest? Because I've never seen it ever before.
The only case that challenged the Commonwealth's right that led to a published opinion was Reddy, which was a 2005 published opinion of the appeals court cited in our papers. The petitioner argued he was entitled to supersede the Commonwealth's jury demand, and the Reddy court rejected that in a published opinion in 2005.
Again, but we're trying to identify, I still can't see it. I see it as an interest. I don't know if it's a compelling interest, and that may
Right,
matter.
When you talk of a jury trial being protective of the community, is that based upon what you believe the purpose of the legislature was, or is that something we've said?
The court has recognized the jury as the conscience of the community, from the United States Supreme Court to this court, cited in the Jury Management Advisory Committee's report, and in countless other cases. However, in the legislature, Acting Governor Cellucci proposed the legislation to change the law after release of SDPs, murders committed by SDPs who had been released by judges, and did it in Governor Cellucci's words, to better promote the public safety.
Right,
and protect the
and with respect to a great governor, that doesn't bind us. So what you're basically saying is judges won't take public safety in consideration. Only the jury will be able to do that.
The legislature has made a policy decision in favor of it.
Okay,
and this
it's the
court has,
legislature. We've never said this, as Justice Kafka has asked you.
I have not seen it in the context of a specific SDP case, but the court has said it in countless other settings, and it would not differ for that reason. But
It's not it, but you keep saying that, but again, I've never seen it articulated. So we have said it, when we go back and read the cases, that the Commonwealth's interest in a jury trial is connected to the voice of the community speaking on public safety matters. We're going to find language to that effect in cases.
in Humphrey v. Cady, the court talked about the jury serving as the conscience of the community for who requires commitment, a different form of mental health commitment, but they talked about that. Courts have talked about the jury serving as the conscience of community in several cases, some of which we cite in our papers. And
so every time the Commonwealth agrees to a bench trial, they're disrespecting the conscience of the community in protecting public safety. It's about 1 billion cases. We've just said that's a disrespect for the voice of the community. Is that right?
I didn't say that, but the legislature has said that
when you say the legislature said, when we look at the legislative history for this provision, are we going to find something that supports that?
Governor Cellucci submitted language to the legislature, which it enacted verbatim. This court in Diggs, looking at a similar instance of changing legislation, adopting virtually verbatim the governor's proposed language and the governor's rationale, this court drew from that to construe the legislative history.
I just want to make sure I understand. So this was legislation proposed by the governor at that time and adopted by the legislature as proposed by the governor. Is that right?
Verbatim.
Okay. Mm-hmm.
Verbatim with the cover letter from the governor, the transmittal letter saying it was to better promote among other things, the safety of the public by enacting a right for a jury trial. And this court has said it will only override a legislative mandate because it's not the court's policy decision to make, it's the legislature's, that it will only override a legislative mandate when there's a compelling constitutional basis.
And we said that in GF to allow for bail for initial proceedings, correct?
Right, and that was somebody held on a probable cause standard for 7 years on a preliminary finding, not beyond a reasonable doubt, and no judge, no court, and 2 have been asked, have ever found that GF would extend as broad to somebody who's been found beyond a reasonable doubt to be sexually dangerous.
Oh, as far as a bail determination?
As far as a pretrial release.
Okay.
2 judges have been asked, it's in the papers, in volume 2 of our record appendix, and they have not. And when the court, if I may just close up, when the court has found the petitioner here has not yet alleged any prejudice to his case from the delay that has occurred so far. And that is the only time when the court has considered dismissing or overriding a legislative mandate. And that has not happened here. And for those reasons, and unless the court has any other questions, the Commonwealth will rest on its brief. Thank you.
Thank you. Okay, Attorney Day.
Good morning. Thank you. I represent Robert LeSage in this matter. And just as an initial matter, neither Mr. LeSage nor I deny the fact that the Commonwealth does, on the face of the statute, Section 9, have a right to ask for a jury trial. But our position is that in this particular case, as applied, the Commonwealth's what we perceive to be a perceived tactical interest in asking for a jury trial cannot trump Mr. LeSage's right to a
Counsel,
timely.
can I ask you, why does a 6-month delay so far shock the conscience? Given that that was the same delay that Justice Gantz was referring to in LeSage.
Well, Your Honor, I think as an initial matter, I know that the Commonwealth has said LeSage is the controlling case here. I would suggest that it's not, for at least 4 reasons. The first one would be that LeSage came along in June 22nd. At the time, there were no trials at all available. The first bench trial at that point was not going to happen until July 1st, and the first jury trial not until September 8th. So LeSage was at a different phase of these proceedings in which nobody had a right to go to trial at all at the time. As Justice Gaziano said a moment ago, in this case now, we could have a bench trial tomorrow. I think tomorrow might be a bit, I think there was some hyperbole there, but we could have a bench trial very soon as we got the doctor's reports ready to go in this case. Secondly, LeSage doesn't really apply to this case because it involved a relatively contemporaneous finding of danger with regard to the 2 individuals who were being held on 58A petitions, and a contemporaneous violation of a release condition for the individual who was being held on a 58B violation. Conversely,
So
in
can
this
I
case,
stop you there and ask you why this isn't a relatively contemporaneous finding of sexually dangerous person, given that, as I understand the timeline, petition number 2 was the jury found in May 2015 that your client was an SGP beyond a reasonable doubt, and then this petition was filed 2 months later?
that's correct, Your Honor. We filed this petition in July of 2015, which is about 67 months ago.
Yeah, but
We-
2 months after he was found beyond a reasonable doubt to be an SDP.
That's correct, right. And then as the trial judge noted in her decision that allowed our request for a bench trial, we didn't get a trial on that 2015 petition due to court congestion until 2018. And then
there are also time periods when you were trying to refresh your expert witness, right? So you assented to much periods of delay in order to get your person examined and trying to get his psychological profile updated, correct?
Yes, Your Honor, but I think that does require respectfully a little bit of qualification. And the reason I say that is, as I'm sure the court's aware, the process for these Section 9 proceedings is somewhat, I don't want to say rigid, but there's a process in place where petitions are filed and then trials are assigned. In this case, Mr. LeSage filed his petition in July of 2015. He wasn't given a trial date until August of 2018, and that was in the normal course because of the congestion.
There are at least 2 of us on this bench right now that presided over the session, so we know
Right.
the timeline. And then 1 year would be fabulous, but that never happens. They're filed immediately, and then there's long periods, and oftentimes the petitioner assents to the delay because it's better for the petitioner.
Well, Your Honor, that's the point that I respectfully would draw a little bit of a qualification to, in that I don't think it's fair to say that Mr. LeSage, excuse me, wasn't prepared to go to trial because he didn't seek funding motions until a couple of months before trial, either in 2018 or at last in 2020. And the reason I say that is we don't know, we being Mr. LeSage and I didn't know if we were even going to need doctors until we got with the QE reports, the qualified examiner reports. So we really weren't in a position to ask for money to hire doctors until we knew whether or not the 2 qualified examiners were going to clear Mr. LeSage or not. And in this particular case, I think that carries even a little bit more weight because, again, Mr. LeSage is now 80 years old. In both 2018 and in 2020, one of the 2 qualified examiners found that he is not sexually dangerous. So I understand the court's question, but I would respectfully suggest that it wasn't as if we were just waiting tactically. We were
Right,
gonna-
no, and could you clarify for me? I'm sorry, I should know this. As far as the pending petition, have the QEs weighed in as far as where he is? I know at least one has to, but has another one?
No, Your Honor. The most recent QE reports we have are from January of 2020, in which case they were split. One said yes and one said no
Okay,
with regard to sexual dangerousness.
You answered my question, they were split.
I can represent to the court, and I do this with great caution, but as the Commonwealth noted in its brief last year, when there was a community access board review, and that was in November of 2019, it was unanimous. All 5 people found that Mr. LeSage remained sexually dangerous. And again, I say this, I think it's relevant, but I received a phone call on Wednesday that said the most recent community access report, which was last month, had a split decision. 2 of the 5 said he was not sexually dangerous. But I haven't seen.
We don't have that in our record though, right?
It's not in the record, no, Your Honor. I just thought I should bring it up because we were asked about if there's been any update to the qualified examiner or expert opinions. So,
Mr. Day, could I ask you, the first-degree murder cases can't be jury waived, as you know.
Right.
So is there a point in time where the defendant constitutionally could request a bench trial in a first-degree murder case?
I would think there probably would be at some point, Your Honor. And what I would draw from that is the First Circuit's dicta and Doodle, which I cite in my brief, which says at some point with regard to one of these cases, as applied, a delay, even on the face of statute is constitutional, a delay beyond a period of a reasonable delay would trigger a constitutional problem. I would suggest that to answer your question, the answer would be that yes, at some point, that for reasons beyond the defendant's control, he just cannot get a jury trial, then he would be entitled to a bench trial to determine whether or not he's
Practically speaking, and I know this might be small solace to you, this case is marked first case out for the resumption of jury trials.
Yes, Your Honor, and I'm, as we all are, I'm aware of this court's guidance as well as the Superior Court's order, Standing Order 9-20. And while I want to be careful how I phrase this, but there is an old saying that I learned before I became a lawyer that no plan survives contact. And the reason I say that, Your Honor, is in this particular context, we still have a long way to go. I think even the government a few moments ago couldn't give us a date.
Everyone has a plan till they're punched in the mouth. That's Mike Tyson's quote.
Yes, Your Honor, exactly. But to answer the question a little more deeply, the Superior Court Standing Order says that these types of proceedings, I guess the presumption would be a 12-person jury trial. SDP trials would be weighed with criminal trials with regard to priority of things, as far as scheduling and that sort of thing. That's going to create, in addition to the constitutional concerns, I think, about continued delay when, as you noted a moment ago, we could have a bench trial much sooner than a jury trial. We're going to run into pragmatic, on-the-ground problems with bringing people in for jury trials when we also have, I anticipate that Suffolk Superior lockup is going to be a very busy place once we get back to any semblance of normalcy. And
Counsel, are you finished, Justice Gaziano?
I am, thank you.
Counsel, can you answer 2 things for me? One is, do you foresee any situation in which a 6-person jury trial would be permissible?
Your Honor, my response to that is that the Superior Court seems to, in its standing order, seems to show a preference for a 12-person jury trial. unless all parties agree to a sixth person. I would feel, I think from my perspective, I'd feel more comfortable if I had to go with a jury trial with going with 12 jurors as opposed to 6. But again, I think our position, my position is that there's no compelling reason why we can't put this before a Superior Court judge.
Okay, one more question then. Can you articulate for me what the balancing test would be when weighing your client's rights to a speedy resolution with the statutory interest that the Commonwealth has? How should that be articulated?
Your Honor, again, I would respectfully note that the Commonwealth's statutory interest, which I perceive as really more tactical than anything else, must yield to the compelling interest that Mr. LeSage, whose liberty is being deprived at this very moment.
So when would the line be drawn in your mind? When, because the statute has to have some meaning. We have to say that the common, it says demand, they may demand a jury trial, but you're saying it yields to compelling interest. The defendant will always have a compelling interest, won't he?
The defendant will, Your Honor, but under
the
these,
petitioner.
right, I understand petitioner, Your Honor. But under these circumstances, the government, I would suggest, has no compelling interest in going forward with a jury trial when we have these continuing delays that we really have no sense of knowing when they are going to end. So the answer to your question is, I would suggest that right now, the line has already been crossed because the trial judge issued her decision on October 5th. Now, granted, she stated so that the Commonwealth could follow its appeal, but
it's a question of the amount of time that would be factored into this.
Well, yes, Your Honor, but I think that time is now passed.
I understand. I'm just looking for language that would express the balance here.
I think the other way that I consider the balance, Your Honor, is that, again, the Commonwealth is going to suffer no real prejudice if we try this case before a judge. There's no reason, and the Commonwealth hasn't argued that it will. But Mr. LeSage,
although it is interesting if you read the legislation filed by the governor, which is, I take it adopted word for word, right?
From what I understand, yes, Your Honor.
And the signing message, or at least the governor's signing message, did point out that that they felt like people were being released improperly by judges at the time. And that's why they made this change to a jury. Whether we can associate the governor's message with the legislature, they do adopt this in its entirety. And it's in response to a particular crisis that happened in 1993, where people are being released and I guess being hurt, right? Somebody's being hurt at that time by sex offenders, yeah.
It goes back to the release of Michael Kelly, doesn't it? 1992.
That's my understanding, Your Honor. But my response to that.
And that feeds through the whole legislative history. That you can actually go right back to that release and murder. But your point is, no matter what the legislative intent is, and however strong it might be, I assume your position, different from Ms. Murray, is that we have to factor into calibrating when substantive due process is realized, the Commonwealth and the availability of a bench trial.
Yes, Your Honor, that is my position. And with regard to the statute, if the legislature had honestly believed that there could be no justice or no community interest without a jury trial, it could very well have made the statute mandatory jury trials like it did for first-degree murder cases. I would also note, and I think it's instructive, of all of the underlying criminal offenses that are predicate offenses for Chapter 123A, in any one of those predicate sexual offenses, the defendant is authorized to waive a jury and proceed with a bench trial. So this idea that there has to be a conscience of the
Can
community.
I ask you to articulate the petitioner's interest here? It's not directly his liberty interest, right? Because he's already been found beyond a reasonable doubt to be an SDP. It's really more his interest in a speedy resolution of his third petition.
Yes, Your Honor. Again, and I think the facts here are relevant to Mr. LeSage in particular, but given his age, he's 80 years old, given his multiple health concerns, the fact that the doctors, the government or the qualified examiners are split as to whether or not he's sexually dangerous. So all those coupled together, I think makes it even a more striking interest for him to be entitled to a timely review of his petition. So he's not held beyond the point of sexual dangerousness, which is of course something that we all want to avoid, anyone being held if he isn't any longer sexually dangerous. And we already have one qualified examiner who says he's not sexually dangerous. We have, from what I understand, potentially 2
Well,
cabinet.
yeah, that goes to the merits. I guess I'm wondering, I was just trying to focus on what the
Right.
government's interest seems to be in exercising its statutory right to a jury trial for all the reasons that Governor Salucci indicated. And your interest seems to be in the prevention of a longer delay. That right now it's been 6 months. You want to just go forward with a bench trial.
Yeah,
It's
but
not
the
really
time-
that you're going to get out of jail. Or the treatment center. It's really a speedy resolution as to what the eventual outcome will be.
That's correct, Ron. As I put in my brief, we're not asking for a release. We're just asking for a timely trial date.
Right. Does anyone have any other questions?
No, Chief.
All righty. Thank you so much, counsel, and we'll take
Thank
our
you.
morning.